To address the persisting challenge of case backlog, the Judiciary has continued to promote alternative dispute resolution mechanisms, including plea bargain in criminal matters and mediation in civil disputes. One of the special mediation sessions was conducted by the Commercial Division of High Court from 18th to 29th May 2026, focusing on banking, loan and credit-related disputes. Out of 527 registered cases, 417 were handled, while 97 cases were successfully concluded, unlocking more than 90 billion for businesses and financial institutions.
The mediation fortnight was a highly successful ADR initiative that significantly decongested the court's docket. But what is very important for us, and which we are very proud of, is that we were able to unlock disputes worth 90 billion shillings, which demonstrated a significant.
Judge Ann Mugenyi highlighted what led to the success. However, there were challenges encountered.
There were some complex commercial and banking disputes which required more time, and we agreed as mediators that even though the 60-day rule applies, if there is some kind of potential towards a successful mediation, would extend the period a little more.
More than 23 judicial officers and mediators participated in the mediation fortnight.
There are misunderstandings that happened before, but because they were not given an opportunity to be able to air them out in a free space, then they begin to speak up.
There are those who came ready to mediate and have their matter settled from the get-go, while there were a few others who came with a negative stance.
But for individuals in banking cases, sometimes you find a witness come and then they break down. So it takes a toll on them.
In attendance was the Governor of Bank of Uganda, Dr. Michael Eting Ego, who commended the Judiciary for that remain a successful mediation session.
Parties who once at the same table could design tailored repayment plans and negotiate interest concessions that no judgment, however sound, would have troubled itself to craft. This is what mediation does, and adjudication cannot.
Dr. Ego, however, proposed measures to further strengthen alternative dispute resolution in the Judiciary.
Streamline the concept judgment in chambers or electronically, so that settlement reached in the mediation room does not lose momentum in a registry. Create the cases for ADR suitability at the point of finding, so that suitable matters are identified before court resources are spent on them.
The Principal Judge, Lady Justice Jane Francis Sabodo, says with alternative dispute resolution mechanisms, it has helped to reduce case backlog and enhance public confidence in the judiciary.
We are celebrating the achievements, but we have also candidly taken note of the lessons learned, and we should also ask ourselves what worked well, what challenges remain. The Commercial Division continues to lead by example, and I encourage you to keep innovating and sharing these successes across other divisions and circuits.
The meeting attracted judicial officers, bank managers, chief executive officers from banks, mediators, parties to commercial disputes, and mediators who outperformed others in handling disputes were awarded. Deborah Namamonde, Viola Nance Subuga, UBC News.